schedule, and so you should be declared disqualified.
So this Form 1 should include whip also?
Manoj,
according to you?
I'm not too sure whether it does.
All posts. All posts.
It does. It does. It does. It does.
Normally does by
Yeah, it does.
practice.
It does. It does. Such members as in Form 1 and names and designations of members who have been authorized.
Who have been authorized by it for communication.
Communicating with the speaker. So which includes, my lords, communicating in any form, including the views. Now please see.
Yes, the communication,
The two communications.
it talks about the speaker for the purpose of these rules. These rules also relate to the
3.5 is also.
so disqualification.
My lords, now I have 3 subclause 5. Where a member belonging to any political party votes or abstains from voting in the assembly contrary to any direction issued by such political party or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party, a person or authority, the leader of the legislature party concerned, or where such member is the leader or as the case may be the sole member of such legislative party, such member shall as soon as may be thereafter, and in any case within 30 days from the date of such voting or abstention, inform the speaker as in Form 2, whether such voting or abstention has or has not been condoned by such political party, person or authority. But today the limited issue before your lordships as far as the 10th schedule is, how does the speaker determine it? They want today the speaker to embark upon and decide what the EC is meant to decide. The legislature party, the political party, according to us, are not distinct. They are co-joint, integral, and organically connected with each other. That is
the bar who's not gone paperless. So you
Well, may I with respect say, from the day this hearing has started, I've been praying that your lordship doesn't ask me this question. But finally it was inevitable and it is followed on me today. But your lordships can be reassured, I'm trying very hard. And I have this with me and I'm taking some classes and lessons in it, my lords. Give me some time, hopefully I'll be there.
before the next CB.
For sure, my lords. For sure.
Fortunately, the bath also don't contemplate.
The other two colleagues have coped up.
Yes, my lords. They are far,
It's just a-
far more able, my lords.
You have.
back to that.
Hours. I put in some extra hours to learn. And what is now?
Manoj, but in all fairness, I've read out a few judgments from this to your lordships. In fairness and in my defense, my lords, I've read out at least a few judgments.
But also like in other matters, he has no defense.
The navigation is the navigation is being done by your junior. You have to also do the navigation yourself. That's also the essence of being paperless. You see,
My lords, your time is precious. If I start doing the navigation at the moment.
all right.
So if that is the layout, please see how have parties understood these rules in terms of communicating to the speaker. Now,
You also can, if you can show us some kind of a practice which is being followed.
yes, that's what I'm coming to. Yes, my lord, that's exactly what I'm coming to. So please immediately now have
This, Mr. Kaul, this only answers half of the contentions raised by the other side, only to show that these names will be forwarded by the leader of the house to the speaker.
yes. No, my lords, absolutely. When I deal with the issue, my lords, I'll deal with it squarely. Since the question fell from my lords, I just attempted to. Just give. Have you got the letters?
Yes, sir.
Have you got the letters? Given it? My lords, one letter is on record. This other letter I don't think is on record, my lords. We've just got copies made. And give one to the other, to Mr. To the other side as well. Have you given to the other side?
No, just yes.
Yes, Courtmaster, if there's an extra copy, could you return it? I need to give it to the other side.
Thank you.
Very grateful. Now, my lords, as late or recent as 6 July 2022, Mr. Sanjay Rao, as leader of the Shiv Sena Parliamentary Party, writes to the Speaker to say, this is to inform you that Shiv Sena Parliamentary Party has nominated so-and-so as the Chief Whip in Lok Sabha in place of Srimati Bhavna Gavli, MP, with immediate effect. And also, my lords, the earlier letter, which is Convenience Compilation Volume 2, PDF 728,
Yes. Convenience.
PDF 728,
Volume 2.
Volume 2.
Page? 7 to 8.
PDF page 728.
That letter of 25th of November 19, Mr. Mohan,
Yes, yes, my lady.
which is already highlighted.
Yes, it was read out, but I now want to read it in the context of the rules. May I, with your lordship's permission?
Yes.
To the Honorable Speaker, Shiv Sena's newly elected MLAs meeting was convened at Shiv Sena Bhavan, Dadar, Mumbai on Wednesday, 31st/10/2019. The meeting was chaired by Shri Uddhav Thackeray, Shiv Sena Paksh Pramukh. All the newly elected MLAs of the Shiv Sena party unanimously resolved that all the decisions of today's meeting be decided by Shri Uddhav Thackeray and authorize Uddhav Thackeray to take all the decisions in the meeting. Thus, Shri Eknath Shinde and Shri Sunil Prabhu were appointed as group leader and chief whip of the Shiv Sena legislature party in the Maharashtra Legislature Assembly. The resolution passed in this regard as follows. Resolution 1. It is resolved in the newly elected MLAs meeting of Shiv Sena party that Shri Eknath Shinde is appointed as the group leader of the Shiv Sena legislature party in the legislature. It is resolved in the newly elected MLAs meeting of the Shiv Sena party that Shri Sunil Prabhu is appointed as the chief whip of the Shiv Sena legislature party, and then all the MLAs.
Who writes this?
This doesn't have a,
This is signed by all the MLAs.
but it has the signature of all the MLAs.
So it's collectively written.
Collectively written, I'm grateful, by all the MLAs. And that is why I said, my lords, to that question, that when we come under the 10th schedule, what you're seeking to do is today create a distinction which does not exist. We have never argued the legislature party is separate or the party under the 10th schedule 2(1) means only the legislature party and doesn't mean the political party. That's not our argument. It's always done through the legislature party, at least in majority of cases, my lords. It's never the party president who writes to the speaker.
The call. Please read para one of that this communication. Para one.
Shiv Sena's newly elected.
Yes. Shiv Sena's
Newly elected MLA's meeting was convened at the Shiv Sena Bhavan, Mumbai. The meeting was chaired by so-and-so Shiv Sena Praksh Pramukh.
Correct.
Right.
Now these 4 lines are very important.
Paksh Pramukh.
Because what was the resolution passed? It is only a communication, correct, of the resolution passed, correct? It was a communication.
Yes.
Correct? It is not that the leader is decided by the legislative party. Please read the next resolution.
All the newly
The
elected.
meeting was chaired by so-and-so, so-and-so. All the newly elected members of so-and-so unanimously resolved that all the decisions of today's meeting be decided by so-and-so, so-and-so.
Manoj, I have right through said the legislature party has the authority of the political party to do so. I am not for a minute suggesting that that is not so. They have the authority to do so. The communication is through the legislature party and the speaker's interaction is through them. Doesn't mean the political party is not involved.
Naturally, the decision is always communicated, whatever is only by the legislative
Yes.
party and or the leader of the
Yes,
legislative party.
yes,
Ah.
yes, that's all that I am saying. Now, my lords, let me straight away now.
Exactly. Somebody has
Otherwise, who will communicate?
Yes, yes.
For the speaker is concerned, it is only the leader of the legislative party will communicate.
Absolutely. Now, my lords, when I come to the case law and distinguishing case laws, once I'm through with the rules, I'll distinguish Mayawati. Mayawati is in a completely different context, and I'll deal with that. Rana, Mayawati, all those line of judgment cited, I'll distinguish each one of them. But let me now, my lords, at least start with the issues at hand, which have been referred to your lordships. Let's kindly come first to the second issue, because Nabam, your lordships have heard arguments at length. On Nabam, your lordships have heard arguments at length, and I needn't trouble your lordships again until unless called upon. Please have issue B, and I'll go issue wise and deal with
B.
yes.
Where are you reading B from?
What are you reading?
Well, that can be
Where are
read
they?
from that order as well. I'll have
Oh, that's
order.
the earliest order.
Yes, yes, I'll just give it. I should have actually pointed that
Okay,
out.
okay.
Order
Yes, the
compilation.
referral order is, my lords,
An order compilation.
23rd of August 2022.
It's there in the
Orders compilation.
orders compilation.
My lords, orders compilation PDF page 34.
Yes. What's the meaning of should be inviting a decision?
That's the question. May I read out?
Yeah.
My lord the Chief.
Yes.
Whether a petition under Article 226 or Article 32 lies inviting a decision on a disqualification petition by the High Courts or the Supreme Courts, as the case may be. Now, my lords, our respectful submission is
Lies inviting a decision.
possibly a direct. My lord, I think the inference was that could your lordships directly decide it?
Well, the other side.
That is
Whether
my.
we can directly decide what the
Yes.
speaker should have decided.
Yes, yes. So, my lords, on that, our respectful submission is that this is in the teeth, the argument of the petitioner is in the teeth of Quixote, because ultimately, my lords, under the Constitution, para 6 of the 10th schedule, the speaker is the sole constitutional authority to decide the issue of disqualification. It is the constitutionally designated authority to decide the issue. And even the proceedings before the speaker have been stated by your lordships to be proceedings under 122 and 212 as proceedings of the House. And even the interference with such decisions, except for violations of fundamental rights or substantive or gross illegality of unconstitutionality, etc., ordinarily is not interfered, but not to say that it cannot be challenged. I'm not for a minute saying it cannot be challenged. Now, what your lordship are being asked to do is to bypass the entire constitutional machinery, not only for the speaker. Even earlier, an attempt was made as far as the Election Commission was concerned, which your lordships refused to grant stay and said, let the Election Commission take a stand on it and then let the petition come here. And that is why at that stage I had submitted that your lordships can't act as the court of first instance. These are coordinate constitutional authorities vested with exclusive and sole jurisdictions. Their decision attains a finality. These are restricted grounds of challenge. You can't today come to the Supreme Court and say the Supreme Court should decide this issue because according to you, these are extraordinary circumstances and the entire machinery should be bypassed. So you decide I'm ex facie, I've incurred the wrath of 21A and 21B. The speaker is biased, nothing else remains to be decided, and thus under Article 32, the Supreme Court of India must act as the court of first instance. That is effectively what your lordships are being told in this matter to do, and which my respectful submission is, my lords, that quite apart from the Shriman Bala Saheb Patil case, where your lordships also held that ordinarily go in a 226 and then come to this court. That's another facet. But in any case, definitely not straight to any court, whether 226 or 32, and say that you decided as the court of first instance. Now, my lords, the same party also relies on Nabam when it suits them. But the reason we came in a 32 that's important today, my lords, is we came in a 32 because Quixoto does not deal with the issue we canvassed, which is in Nabam, which is post-Quixoto, where a 5 judges bench of this court, and which today still holds the field, says that it would be improper and inadvisable for a speaker to proceed, continue, or conclude a disqualification petition while his own disqualification is pending. It is for this reason that we came in a 32 to say that A, our lives were in danger, we couldn't go to Maharashtra. B, the speaker cannot assume jurisdiction. So to say that we are hit by Quixoto, we were not hit by Quixoto, and that's the distinction we drew. Whereas your contention is clearly hit by Quixoto. Because in your case, you're wanting the court to do something without the speaker even exercising its jurisdiction on the matter. Secondly, my lords, the speaker has won the confidence once. The House has again reaffirmed its faith. And we keep going back to the same argument to say that if that disqualification had been decided, then it would go back to the date what Justice Shah put to me yesterday. And I'll come to that argument. Well, even if a disqualification relates back to the date of the events, doesn't mean any action taken in the meantime gets annulled. In Rana, what your lordship said that when the speaker decides, he only looks at the events on the day the disqualification petition was moved, and at no event post that. That's what Rana said. But those series of judgments that your lordships have given on the point that there is no bar to an MLA or an MP till his disqualification petition is decided from participating in the proceedings of the House, because a constituency can't go unrepresented. He has to be there. Can't mean that all those decisions will be annulled, because the arguments ought to be raised that in the process, the trust vote, everything else will get annulled, and thus your lordships should restore status quo ante, because your lordships created and order created and toppled the government. That's the argument being made to your lordships. My respectful submission, my lords, is it's legally and constitutionally an unsustainable proposition. It's an unstatable proposition in law.
Qualification under the Constitution is vested in the governor.
Please, my lord.
Who takes issues of disqualification are vested in the governor, and he, if he chooses, takes the advice of the Election Commission.
Yes, that's 191(1).
Also, yeah.
And 191(2), as your lordships rightly said, is the speaker.
No, 192 talks about.
Yes.
It takes within its sweep.
Yes, my lords are absolutely right.
If any
Your lordships are
arises
absolutely
as to
right.
whether a member of the House clause 191(1), it will be referred to the governor.
Yes,
Governor takes
yes,
it.
yes.
In any event, decision of the speaker, the judicial review is only decision-making process, but asking the court to decide what the speaker is to decide is a leap.
Yes. Yes, ma'am. Absolutely. I'm grateful. I'm very grateful, ma'am. I couldn't- Now, Manoj, would your lordships be kind enough to now move to the next question? Can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision by the speaker? Because my respectful submission is, how can the court ever deem an MLA to be disqualified pending a decision? Would that not necessarily circumvent the entire constitutional authority, my lords? And would the functioning of the legislature not be put in jeopardy by imposing temporary disqualifications? And would it not hamper electoral democracy that a whole constituency goes unrepresented? Especially when your lordships have time and again held that he is entitled to participate pending his disqualification. And it is sought to be argued that he should be deemed to be disqualified. Without the speaker exercising his jurisdiction or the governor in consultation with the election commission under 191(1) or 191(2), how can the court say that an MLA or an elected representative of the people is deemed to be disqualified till the decision is taken? It's like annulling the mandate of the people, my lords, and buys the Supreme Court as the court of first instance in an interim order. Would your lordships be kind enough to have the next question? May I, my lords, with your lordships' permission?
Yes.
What is the status of the proceedings in the House during the pendency of disqualification petitions against the members? Now, my lords, right from Kuldeep Bishnoi, Pratap Gowda Patil, Shivraj Chauhan, and Nabam Rebia, your lordships have time and again said that pending disqualification, he participates with all the vigor and robustness and legality as his command in the proceedings of the House. There is nothing which disentitles him from participating in the proceedings of the House. And can it be said that tomorrow, if he is disqualified, all those proceedings that he participated in
Article 100.
are null and void? Suppose there were decisions by his vote, a decision turned. So that will be annulled. Enough in this context to have Article 189 for a minute.
189 and 100 go together.
Yes. So, my lords, 189 is the mirror.
Assembly.
Great, great.
That's what I was saying. Article 2.
Yes, my lords. My lord, the Chief Justice has?
Yes. Vedu.
Justice Shah has? A house of the legislature of a state shall have power to act notwithstanding any vacancy in the membership thereof, and any proceeding in the legislature of a state shall be valid notwithstanding that it is discovered subsequently that some person who was not entitled so to do sat or voted or otherwise took part in the proceeding. Quite apart from the provision, my lords, the law is laid down by your lordships. The moment your lordships permit and say that a MLA is entitled to participate, the necessary corollary is that whatever he has exercised in terms of his vote, the proceedings, tomorrow he votes in a budget. There are appropriation bills. There could be any other decision taken. So will we say that just because he's participated in a trust vote, your lordships are told annul everything? Because had he been disqualified, he could not have voted. And we have presumed he will be disqualified, or he's already incurred the wrath of 10th schedule. And thus the entire process is vitiated. That's the argument being made to your lordships, and that your lordships today should annul everything from the resignation, swearing in of a new government, speaker winning the vote of confidence, the government winning the trust vote. Everything should be annulled because everything was caused by your lordships order, and your lordships are responsible for the toppling. Thus only your lordships can correct it. That is the argument being made.
Which are the judgments?
My lords, the judgments are Speaker Haryana Vidhan Sabha versus Kuldeep Bishnoi, 2015, 12 SCC, 381, para 46 and 47. Then, and I'll later give the compilation numbers it's part of the compilation. Then, Pratap Gowda Patil versus the state of Karnataka, 2019, volume 7, SCC 463, para 4 and 7.
2019, volume?
7, SCC, page 463, para 4 and para 7. Then Shivraj Singh Chauhan versus MP Legislative Assembly, 2020, volume 17, SCC, page 1, para 79 and para 80. Then Nabam Rebia versus Arunachal Pradesh Legislative Assembly, 2016, volume 8, SCC, page 1, para 188, 189, and para 191 to para 194.
Yes.
That's quite apart that it is absolutely obvious from these judgments that he retains the right to participate. Also see the danger, my lords. If such MLAs against whom the disqualification is pending and they are suspending during pendency of their disqualification petitions, it would open up serious possibilities of misuse of 10th schedule, and I'll give some instances. Participation, of course, gets affected. So you, in a way, fix the eligible voters who will vote in the House. And major decisions to which some of the MLAs could have been inconvenient do not participate now in. And also, my lords, a quick.
That's very clear, actually, a matter of first principle, because the mere pendency of the disqualification petition doesn't affect the status of the member.
And my lords, the moment your lordships have said they have every right to participate, quite apart from Article 180, that's the end of it.
That point continues to be a
Even 181 also, Article 181. When the speaker against whom the discussion only in the particular meeting,
yes,
correct, he cannot. Otherwise, he can speak. Even that meeting also he can speak.
Yes, absolutely right. But my lords, this point, your lordships are absolutely right, is very clear, but it acquires some significance because the argument being raised is that if his disqualification, he is held to be disqualified, Rana says it will relate back to that day, and thus any action taken with his vote, with the crutches aid of his vote, stands vitiated and suffers from a constitutional sin. That's why I said it's important. Because your argument is that it relates back And because it relates back, every vote given by him, including the trust vote, goes, and thus your lordship's in exercise of your lordship's extraordinary jurisdiction must overturn everything that has happened and act as a court of first instance.
Absolutely.
Then, my lords,
Absolutely.
Would have a very serious consequence according to you. Suppose the budget is passed and he has participated and cast his votes.
absolutely.
Correct? If it is to be restored back, correct, to his original one, then all this budgetary provision, all this.
Well, I can't put it better. Absolutely. And that is what is being sought to be argued. And this is, Rana never said this. Rana is, when I come in, I'll distinguish the judgments. Rana is in a different context. Mayawati is in a different context. And you pick them up and apply them to a situation where they have no application at all. A line here, a line there, and you say that's the settled law on the point. Now, my lords, ground E, with your lordship's permission.
The member of legislators emolument act. There is a provision. Check up. What is the consequence of an MLA or an MP being disqualified upon his emoluments? There is a separate paragraph on that. Also,
My lord
gives
said
us an
this is the
indication.
MLA.
Sorry?
Your lordship said the MLA emolument.
Emolument. Just check that up. There is a provision.
I will. I'll look it up. I'll look it up today. Now, my lords has ground E. Sorry, question E. Question E.
It's relating back.
My lord, the Chief Justice.
Yes.
If the decision of a speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? That's why, my lords, I put this, because that's been what they've been arguing right through.
Mr. Cole, D and E can be collected.
Yes,
go
yes,
together.
yes. But the reason I'm laying so much emphasis on is because a large part of this argument, where your lordship's order of 27th and 29 becomes according to them the cause of all that has happened, only your lordships can rectify, and the solution lies in this because it relates back to that day, and because it relates back to that day, and trust vote also falls in between, everything should be annulled.
Will you explain on the basis of Rana and other judgment that they have cited?
Well, what I'll do is,
No, whenever.
I'll in one go explain each of those judgments, because I'll explain Brahmanand Reddy, Rana,
So you
Nayak,
the
each one of them
judgments.
I'll distinguish
You will take up the judgments in one lot at the
in
end.
one lot,
All right.
because my lord,
Fair-
I have to cite my own judgments and I have to distinguish the judgments cited
all
by
right,
them.
fair enough. That would be
Relating
more
to
coherent.
relating back.
Sorry.
All this relating to relating back.
Yes. So, my lords, all those issues of Mayawati on political party versus legislature party in the 10th schedule, Rana status quo ex post facto, and the others, my lords, as I go along, I'll deal with them. So, my lords, again, as far as this question is concerned, my argument remains the same as I just addressed your lordships on the previous. Yes. The law, the provisions of the Constitution, it cannot be any other way. This is the only way it can be. Because the consequences for an electoral democracy are disastrous. Constituencies go unrepresented. No one is there just because the disqualification petition is pending. And he will not participate in, especially when your lordships, this is no longer res integra. Your lordships have ruled on it, on judgment after judgment. Now, my lords, would your lordships be kind enough to have?
That's why in the context of the judicial function we have developed the concept of the de facto doctrine. So even if the appointment of a judge is found to have suffered from an invalidity, that will not render all the judicial acts as invalid.
Absolutely. I bow down to it. I bow down to it.
Be clearer.
Now the next question is question F. What is the impact of removal of paragraph 3 of the 10th schedule?
Mr. Kaul, I have one small doubt. How are we going to deal with the situations which is emerging from time to time? Disqualification application is filed, speaker doesn't decide. And then the matter goes on. He participates in the assembly and a disqualified member continues. At what time and what is the time limit within which he needs to decide? Because till a decision is taken, disqualification issue is not decided, so therefore it's pending. This problem has been arising in a number of cases. Megha Chandra is one judgment where Nariman had to say that within a time limit he has to decide, but that's referred to a larger bench saying that you can't direct the speaker to decide.
And that,
But where are we going to
well, your lordship are
deal with a
absolutely right.
situation like this, where speakers don't decide and events overtake that, and either matters become infructuous or the house is dissolved by flux of time.
The lordships are right. It will have to be considered. Should there be a timeline? Should there be a time-bound process? Should it be decided within a time-bound process or not? As your lordship said, that issue whether such a direction could be given
Can
to
you
the
just pick
speaker.
up that order where it's referred to the larger bench? That Megha
Just
Chandra
Nariman's
reference to
judgment.
larger bench, can you just pick that up?
Yes, yes.
I'll get hold of it, my lords. Let me just also apply my mind to this. It's fallen from my lords. But quite apart from the fact, my lords, when we were arguing Nabam, where we said that as far as the speaker's own removal is concerned, the assembly and the constitution itself provided a reasonably strict timeline on how it could be followed in terms of when the notice to be given, when is it to be decided. Possibly some kind of a timeline. As the lordship said, I'll have a look at the issue. Now, my lords, as far as the removal of the 10th schedule is concerned, my lords, firstly, this was only a defense against incurring a wrath under the 10th schedule. 3 and 4, para 3 and 4 are only defenses under the 10th schedule. That defense of 1/3 having split from the party is no longer available. But to me, it is wholly inconsequential because my case has never been that I have split or gone anywhere else. My whole argument has been that I represent the majority rival faction within the party. Neither have I given a support to any other political party, nor have I said I will not support a government as far as my own political party is concerned. As long as the coalition is something we've expressed our concern with, I've not gone anywhere. So this whole line of merger, split, it is not a case of a split, my lord. It's a case of a rival faction, or what the rule para 15 of the symbols order says, of a splinter group within the party.
What's the difference between a split and a
Well, split is
and
it?
split on the one hand and what you are suggesting?
Well, the difference between the two is that split is an issue where you, as a defense, say that I will not incur the wrath of 10th schedule. I have not even voluntarily left the party. In the case of a rival faction, I claim that I am the political party and recognize me as the political party under the symbols order. Please have that symbols order for a minute. It's a question that your lordships have put to me, a pertinent question, and this will answer. Please have statute compilation, PDF page 155.
The fact that there is a
seek your lordship's indulgence only for a minute, Lords. I'm taking this liberty only because I have to move an urgent application before my Lord Justice Shah chambers. No, just liberty to go to my Lord's chamber. That is all that I seek for that.